Let's start the panel. So good day, everyone. So we are at the 6th day of the week-long EU-India Summit, and we have had quite many panels on various topics. And today's panel, we focus on the business and human rights theme. I'm Induja, and I will be the moderator for the panel. As a short description, this panel will look at the growing mandatory human rights due diligence legislations in Europe. The background is that the last year, the European Commission said that they are ready to legislate a mandatory human rights and environmental due diligence law for the whole of Europe. And so this panel will definitely be looking at how this could impact on minimizing the corporate human rights violations in India. This would be a specific interest to many civil societies back in India, as well as business managements to know about these. So on this topic, we have 5 interesting panelists who had been working on business and human rights and can give various perspectives from the civil society, both from Europe as well as India, and also on workers' rights perspective, and also from management side. So let me introduce to them without any further delay. So we have Dr. Amir Ullah Khan, who is the development economist and professor at the MCR HRDI of the government of Telangana. He is also a visiting professor at GIS, Indian School of Business, and at Nalsar in Hyderabad. Amir is also a business columnist for the Live Mint, and he had also been a senior policy advisor, deputy director at the Bill and Melinda Gates Foundation, and he's also a director at the India Development Foundation. We also have Johannes Blankenbach, who is the EU researcher and representative of the Business and Human Rights Resource Center, UK, and he's currently based in Berlin. Prior to this, he was a researcher at the German Development Institute and worked on knowledge cooperation across the institute's managing global governance network. And his research interests lie in the fields of corporate human rights due diligence and voluntary sustainability standards, as well as in their interconnections with SDGs. We also have Ani Khan, who is the South Asia researcher and representative at the Business and Human Rights Resource Center. She is also a licensed New York State attorney, and her previous experience includes Amnesty International, American Bar Association Center for Human Rights, US Institute of Peace. In her work, she has focused on research and advocacy-based work for human trafficking issue, as well as on business and human rights. Then we have Dithhi Bhattacharya. She is the executive head of the Delhi-based Center for Workers Management, which is a pan-Indian organization focusing on workers' rights. It is also a workers and trade union resource center. Dithhi advocates for workers' rights and focuses on the rights of workers within supply chain as well as with informal sectors. And finally, but not least, we have Marie-Sophie Keller. She is a business and human rights lawyer from Germany. She is also a researcher for the German parliamentarian Michael Brandt. Formerly, she worked with the Chennai-based Vetiver Collective in India in the field of environmental protection and community empowerment, and was involved in the struggle to hold Unilever accountable for its criminal mercury contamination in Kodaikanal. So we have a very wide range of perspectives that we can hear today. So welcome all of you. So initially I will give the floor to Johannes, who will give an overview of the mandatory due diligence, and then this will set the further discussion. So Johannes, you can tell us why there is a growing momentum for mandatory due diligence laws in Europe right now.
Yes, thank you so much, Induja. I'll try to give that overview, hopefully keeping it brief. First of all, let me say that I'm very glad and honored to be here. Thanks so much for having me and for this invitation. And maybe also a few words about my organization, the Business and Human Rights Resource Center. We are an international NGO working to advance human rights in business. So we cover and analyze business and human rights related news and developments across the globe in different languages. We help communities to get companies to address human rights concerns. And we also provide companies with an opportunity to respond to allegations of abuse, to provide that platform for transparency and accountability in some sense. And our regional researchers are located across all world regions. And in fact, my colleague Annie and I were two of those regional researchers covering different regions. So to come back to your question, Induja, and on why there is growing momentum and what this is all about, basically, and what companies' obligations are, and what companies' human rights obligations are under current frameworks and forthcoming frameworks. So to put this very simply, companies should respect human rights, or with a few more words, companies should avoid infringing on the human rights of others, and they should also address adverse human rights impacts with which they are involved. This wording is from the UN Guiding Principles on Business and Human Rights, which you may all be aware of. It's a key reference in this business and human rights debate, and also in business and human rights practice. And it's a reference that was unanimously endorsed by the UN Human Rights Council back in 2011 already. And these UN Guiding Principles assign responsibilities to states and businesses and rest on 3 pillars. And one of these pillars spells out the corporate responsibility to respect human rights. And human rights due diligence, which is in the title of today's session, human rights due diligence is then the key operational procedure or standard of care for companies to implement their responsibility to respect human rights. So it's not an end in itself, but it's a means to an end. And human rights due diligence was also introduced with the UN Guiding Principles, and then later also extended to cover corporate environmental impacts and also corporate impacts on governance, like corruption, for instance. And due diligence means companies should identify, assess, prevent, and mitigate their adverse impacts on people and planet, wherever these impacts occur. This can be in their own operations at home or abroad, but it could also be across the global value chains, so at the level of suppliers. And this would certainly include an EU company's operations and direct or indirect suppliers in a third country like India. And under this due diligence principle, companies should also publicly communicate on their due diligence to provide transparency. And the UNGP is also very clear that companies should provide remedy to affected people in cases where harms have already occurred. And due diligence is a very scalable, highly context-specific and continuous process. And what it should not be turned into is a shallow tick box exercise or an end in itself. As I said in the beginning, it's really to serve that ultimate purpose of ensuring respect for human rights and effectively preventing business-related human rights harms in the specific context. And meaningful, genuine due diligence will usually have to go beyond just policing or even auditing suppliers. It's rather about long-term partnerships in supply chains, about working together with suppliers to address human rights issues, and lead firms, big brands, etc. in the EU. They should also analyze and adjust their purchasing practices and business models if these contribute to human rights harms in value chains and undermine their due diligence. So yeah, this goes much beyond traditional CSR, I would say, and probably often requires a mind shift within companies. And another key measure to conclude on that, what due diligence means, another key measure or prerequisite for effective due diligence is meaningful consultation and involvement of local stakeholders and rights holders in global value chains throughout all the due diligence steps, throughout all this process. This whole process, and rights holders includes, of course, workers, communities, human rights defenders in the global south. So these should be consulted, involved in a meaningful way. Talking to those rights holders is key for proper due diligence. So the question now is, why does the EU and why do other European countries consider introducing binding legislation on corporate due diligence, which so far has been more of a soft law, voluntary concept? Well, the reality of current voluntary due diligence implementation is in very stark contrast to what I outlined above. Or in other words, the voluntary model of due diligence implementation has pretty much failed. According to an EU Commission study, only 37% of business respondents currently conduct any environmental and human rights due diligence. There are human rights benchmarks that I won't go into detail here, but they're called corporate human rights benchmark or know the chain. And they look at companies' due diligence disclosure, and they also produce similar results. Very few companies conduct due diligence and disclose it. This is also mirrored, of course, by the hundreds of allegations of corporate abuse that organizations like the Business and Human Rights Resource Center take up each year. So in 2020 alone, this involved companies headquartered in the European Union over 200 times. So we received over 200 allegations of abuse just last year. And finally, access to remedy, including judicial remedy for victims of abuse, of harm, has been extremely difficult. And only, I think, of roughly 35 cases against EU companies in EU member states courts brought by foreign victims in the past 10 years, just one case has really, one lawsuit has really succeeded. And for others, some sort of a settlement has reached, but many also some sort of settlement was reached, but many other cases just failed and were kind of, yeah, not successful from the perspective of the victims. If I still have a few minutes, let me just briefly say that forthcoming EU legislation meant to address both issues. So it's about legally requiring EU companies to conduct due diligence and really take action. And this explicitly includes action on extraterritorial risks and impacts in the global operations and value chains of EU companies. And second, this forthcoming legislation will also be about improving access to remedy and especially judicial remedy for victims of business-related human rights abuse before EU member states courts under EU law, if that's the most favorable for the victim. And both aspects are actually connected because only legal liability for harms will ensure the law has enough bite and a strong preventative effect. And NGOs have been fighting for all of this for years, led by the European Coalition for Corporate Justice, ECCJ, and many other organizations. And interestingly, even businesses more and more often see the need for regulation and speak out in favor of regulation and a level playing field where sustainable practices are no longer a competitive disadvantage under market conditions. Let me briefly conclude by outlining where the EU legislative process currently stands. So, as you said, Induja, the EU Commission announced in spring 2020 that it would propose an EU law on mandatory corporate due diligence as part of broader legislation on sustainable corporate governance. So there will be other aspects added to that. And then in parallel, or a bit later in 2020, the European Parliament started working on a parliament position on the shape such a law could take, a due diligence law. And this position is then meant to inform a full legal proposal developed by the Commission. Right now, actually, it's due in summer this year, the Commission's proposal. In the meantime, the Parliament has adopted its resolution in March 2021 by a very large majority. It's the most tangible text we currently have, although it's not the final law. One should be clear about that. I'm happy to comment on its contents later if there's time. Generally, civil society welcomed the Parliament report and resolution as a strong signal, but also said the Commission will have to go further in its own legislative proposal, which is due in a few weeks or months. And then the Commission's proposal will then go to the EU Parliament again and to the EU Council of Member States. And in the end, these two bodies have to agree and jointly adopt the final law. So yeah, and the length of this procedure will depend on how far or how close to each other the Parliament and EU Council positions will be. It's a bit hard to predict. If it's a directive, by the way, this then also has to be transposed into EU member states laws, and it could take another 2 years. So it's still some way to go. And sustained effort by all the players is definitely required, sustained advocacy. I think I'll leave it here, to give time to my colleague and the other panelists.
Yeah, sure. That was great overview, Johannes, because you have said that there should be a mindset of changing from the voluntary CSR to a mandatory one, and also it's interesting to hear that these laws would create a legal liability on the businesses. So I would like to hear from your colleague Annie. Can you give what do you see the impact of these due diligence laws for the Indian context?
Hi, Induja, and good afternoon, everyone. Thank you so much for having me. It's a pleasure to be here. Thank you, Johannes, for beautifully outlining kind of where we are with EU mandatory human rights due diligence. So as a South Asia researcher, I've been involved with looking at and sort of analyzing where the implications of EU mandatory human rights due diligence would actually fall in India and what that might look like. So to shed some light on the perspective and the potential implications, I'll mention first what we do have in place here in India at the moment when it comes to obligations of responsible business. So while we do have national voluntary guidelines, which we refer to as the NVGs, these include 9 principles covering a broad array of social, economic, environmental, and governance issues. These are only voluntary in nature and do not make it mandatory for companies to report. In 2012, however, SEBI, which is the Indian Securities and Exchange Board, did mandate the annual business responsibility reporting, BRR, which is a reporting framework based on the NVGs, and it requires the top 100 listed companies by market cap to report. But clearly, this fails to capture the full business landscape of the country, and it fails to account SMEs, for example. Finally, in 2019, the Ministry of Corporate Affairs revised the NVGs and released the National Guidelines on Responsible Business Conduct, NGRBC, and has also set up a committee for business responsibility reporting. So while there certainly do exist some element of mandatory reporting, which is mostly a mix of voluntary and mandatory reporting, if we're being honest, this is far from enough to ensure business practices are inherently responsible and have a rights-respecting framework at their core. Also, just to mention, India actually does have 31 ESG reporting provisions, but out of these, only 60% are mandatory and very few of these are made public. So as Johannes brilliantly alluded to earlier, there's definitely a strong linkage that we must make between a company's headquarters and their local supply and value chains. So when we talk about mandatory human rights due diligence in EU companies, we can look to cases like the Total case and other ongoing litigation where activities down a company's supply chain do indeed fall under the jurisdiction of the European country, even when its activity is thousands of miles away. So therefore, at least on the books, corporations are accountable according to the law. So we would imagine that EU companies would soon be under similar scrutiny for their business activities here in India, should mandatory human rights due diligence pass at the EU level. And similarly, it's important to note that responsibility is not only on the multinationals themselves, but also local suppliers must be on notice of the EU level changes and to know that they're equally on the hook should mandatory human rights due diligence become hard law. It's essential that multinationals proactively work on this and prioritize it when selecting and working with suppliers in the country. So combining the EU's progression towards mandatory human rights due diligence with India's very own efforts and a considerable number of foreign companies investing in India, naturally more so as companies look away from China and are incentivized by India's new labor laws, Indian companies will most certainly soon be required to monitor and mitigate risks in their supply chains. Thus, it's critical that Indian business be prepared for this shift. And I also just want to lastly mention, there's a deep concern for the way national and global markets are operating, and this is exacerbating issues like increased inequality and environmental issues. We see this more than ever in the COVID-19 experience that we all find ourselves in today. So while we do see that companies are taking positive steps, it's important for the government to publicly be encouraging this, which we've not seen much of to date. Thanks. I'll hand it back to you. Thanks.
Yeah, thank you. So yeah, that was a great overview again, and we have Amir here, who has a great background on business. So, but we will get to the business aspect later. Right now, let's look at the workers' perspective because we have Dithhi. You heard about the developments that is happening. What do you think currently, do you think the labor laws in India is enough for the workers who are directly or indirectly working with the European companies? Or what do you think is required as a bargaining power for the workers to mitigate the human rights violations within the supply chain?
Thanks, Indra. Well, of course, I don't think that the labor laws are sufficient, because what the labor laws were not sufficient. And now that the labor laws have actually started changing, they have become less than sufficient. And more what we are seeing is a flexibilization and informalization of labor that's happening. And I just want to actually respond to it in a larger sense, to respond to what the EU guidelines are, and then come to the specificity of labor. The question is that when we are talking about the whole idea of the guiding principles, or we are talking about the new due diligence laws, we are looking at it from a perspective where we are seeing that the companies are being expected to change their purchasing practices, their business models, to be able to fit themselves in some kind of a structure. But what we are not possibly considering in this is, why are we here at all? The question is that the companies have come to the global south to make more profits. They've not come here to follow laws. If they were here to follow laws, they could have been where they were. They didn't need to come here. They've come here to not follow laws. And hence, on the other side, what we are seeing is that the laws are being flexibilized. The labor is being made cheaper and cheaper and cheaper, and more, all the fetters that were there for capital are being taken away. So you cannot have both two sides. These are the two sides of the coin, it's supposed to mean. That when there is somewhere that you're tightening the noose, the other side should also be allowed to tighten the noose. But that's not the case. The other side, so the global south, is loosening everything, whereas the global north is saying that they're going to tighten the noose on the multinationals. The question is it really that they are really trying to tighten the noose? Or is it that this tightening of the noose is only a mirage? Because somewhere we need to understand that there is a consumer out there which is buying the products that is produced in the global south, who's no longer willing to buy products that are produced by the blood and sweat of Rana Plaza victims, or the Bhopal gas victims, or anybody, or just the fact that somebody is bonded labor, or is being produced, or something is being produced by child labor. So everybody wants to have a free conscience. The consumer in the global north wants to have a clean conscience, that I am buying products which are following some laws. But if you're buying products which are following laws, then why are you willing to buy products every day for cheaper and cheaper and cheaper prices? You can't have it both. You can't have a t-shirt for €2 and yet say that there is no exploitation in the supply chain. There has to be exploitation in the supply chain to produce a t-shirt for €2. It is not possible that you can produce a t-shirt with €2 and yet have your conscience free. So what I think we need to understand and recognize is that this due diligence law is just like what it was earlier with the CSR and the voluntary guidelines. It was a stamp. It was a stamp which allowed people to feel good, that this is ethical. This is good for us. This is something then we don't need to go and question. We can buy this product because we know that they are following a due diligence law. So this is where we come from. So this is about cleaning up the mess on the top while the mess remains at the bottom. So we just clean the surface and we feel good about it. Okay, it's a clean surface. The mirror is clean. We don't know what's behind the mirror, but we don't need to know because it's a clean mirror. So the question that we have to ask ourselves is that, is it possible to have due diligence laws that are really actually all about cleaning the surface? Because if you look at the Total law, the Total case, because at the end of the day, the French law is the only law at this point in operation. So which is what we are all looking at this point. So if we are looking at the Total case, what did finally happen? What do you expect a Global South affected group of people to be doing? Go to France and fight a case? Is that really possible? Really not. Then even if you do manage to do that you do manage to find some people.
Sorry. Yeah, go ahead.
Okay, just give me 1 minute, which is, if you do manage to find the money and the resources and the people who are going to support you in a case like that in Europe or in any country in Europe, do you really believe that that is a sustainable model where finally the case that the defendants had to fight is whether they should go to a consumer court or whether they should actually go to a court which decides it to be a liable company? Whether it should be done by those who are already part of the system who will decide the case, or those who are actually judiciary, which will decide the case. So we are in a situation which is a very skewed situation, which is not really willing to tie the noose. We are willing to clean the surface, but we are not willing to tie the noose. And I think that is something that we need to understand. This may be a good first step, but this cannot be a step which will then we believe that this will improve and improve and improve and somewhere we'll get somewhere, but no. This is only about cleaning the surface and the corners and maybe the middle a little more. And then when dust covers itself, we can again clean it up a little more. So it's like that. So I think that's something that we need to keep in mind.
Yeah, thank you. I agree with you. This should be this should not be the end, but the means to an end. Yeah, I think does Mary Keller have a view on this? Because access to remedy is a big part of this upcoming legislation, because there is legal liability. How do you see this? Because there is already a German amendment as well as this French law. How do you see the access to remedy for affected parties in a country like India, a third country? I asked to Marie-Sophie.
Sorry. Maybe I can just give you a little run through the German law so that we also can set the scene here, because we have been waiting for this law for a really long time, since the voluntary national action plan for business and human rights didn't really seem to work particularly well. Only less than 20% of German corporations implemented the voluntary measures, which is the due diligence. And so the law finally in this year, March, was passed in the cabinet as a draft. It already had its first reading and will be in 2 weeks in its second reading, which is really exciting. So there's a lot happening there. But yeah, in terms of liability, that is one of the biggest weaknesses of the German law. The narrative of the ministers that worked on this law was that this will be the most far-reaching law in the world. And I'm not sure how much I can agree with that. It will be applicable to corporations with more than 1,000 employees starting from 2024, which is less than 3,000 corporations in Germany. And another really problematic part of this this law is that the due diligence will mainly be for the direct supplier, and then everything beyond the immediate supplier will only be when there's a complete or substantiated evidence that there's problems in the supply chain. So it's really a really narrow focus on due diligence. And in terms of the civil liability, there's no actual provision implementing or asking for a German civil liability regime. It still relies on the international private law regime, which is already in place, and they sold it as a really big success that they are now allowing unions and civil society organizations to also be able to bring a case under international private law. But the problem is that the material law with that isn't made any better whatsoever. And as you probably know, only one case in Germany has made it to a German court, which is the case of KIK in Pakistan after the Ali Enterprises factory fire. And so I don't really see how this will substantially improve the rights of victims in other countries, because it will still be very difficult to bring cases in German courts. So the one thing that is somewhat interesting about the German law is that it establishes a German agency that will implement the law, called the Federal Office for Economic Affairs and Export Control. It will, check the reports, and it will be able to collect some evidence and give some fines to the corporations. So this might be interesting. One negative thing about this is that we already saw the way this agency works when it comes to arms exports and the checking where the weapons or whatever arms we're talking about finally end up, and they are shown a pretty close cooperations with the arms corporations. So since this agency is closely linked to the German Ministry for Economics, we can expect that there will also be a somewhat close cooperation here. And while there's a few other weaknesses with the German law, for instance, there's only somewhat weak environmental due diligence. Climate isn't really mentioned. But so I think for the Indian context, we can say that if there's the Indian supplier is a direct supplier, there might be somewhat of an a better link. I put a lot of hopes into the European endeavor, the European directive or regulation, because that actually does look at establishing a liability regime. And a problem with the German one is that especially the ruling parties have already said at various instances now that they see the German law as a blueprint for the European regulation or directive, which I see problematic, because it might mean that they try to weaken it in terms of the liability. But I guess we'll have to wait and see, and hope that it will be the other way around, that the Germans will have to step up their national regulation. Yes, we'll leave it at that.
Yeah, that's quite valid points. It looks like there's more cons than pros. But another thing that I wanted to ask is, this question is for everyone, so anybody can take. Well, in local settings, there are different issues that are valid for each country. For example, in India, There was a 2019 report by Ethical Trade Initiative which said that caste-based discrimination is pretty much embedded in the supply chains. So this is fairly common in South Asia itself. Like, how do you see a mandatory due diligence apply to such scenarios, which are very country related? Yeah, does Johannes wants to say?
Sure. Thanks. I mean, I think this is it's a good question, because I think this is really what the kind of meaningful, genuine due diligence would be about, to really look into country contexts and be very context specific and develop context specific measures to address these risks. I would say caste-based discrimination is very well covered by what we have in terms of international human rights treaties, and companies would be obliged to look at all these human rights instruments that are out there, and then base their measures upon those instruments. And of course, caste-based discrimination would have to be included in any meaningful and relevant risk identification and risk assessment. Otherwise, it's a failed exercise if a brand does not consider this and include in its risk assessment. And maybe if I can also comment on what you said, Dithhi, I think we are very much on the same page in the sense that EU NGOs really fight for due diligence that is not just a technical fix or something that companies just add as a CSR measure or so, while they continue with fast fashion exploitative business models. But what we really hope is that through that due diligence, through proper, genuine risk assessment, etc., companies then also come to the conclusion, okay, we actually have to change also our business models, and we cannot just carry on with it with that fast fashion, for instance, that you mentioned, and offering these very low prices. I believe, I mean, it's companies have some discretion in how they calculate their profit margin, etc. It's not that everything has to be transferred one-to-one to the consumer. I think companies have some discretion, and we should push for that. But I mean, indeed, I think a T-shirt for €2 in a German supermarket is just not, in line with any kinds of human rights consideration or requirements. And as I said, I would hope meaningful, bold due diligence legislation that is also enforceable through first of all administrative sanctions, penalties, but also through this bottom-up access to remedy and liability. We would hope this really leads to business model change, where these fast fashion models are also abandoned at some point. And this is what we are fighting for as NGOs. I'll let others respond as well.
I would like Dr. Amir to step in if you have any response here.
Yeah. Thanks, Induja. Thanks, everybody. I mean, first of all, Annie, who clearly gave you the entire picture of where we stand in India, and then Dithhi for having spoken about what the laws say and where we are at the moment. On a slightly broader issue, see what's happening in India right now is that we are trying to emerge from the shadow of poor economic growth for a few years now. What you must understand is that India, had unprecedented and a maddening pace of growth in the first decade. So from 2004 to 2010, India's growth rate was really remarkable. In the sense that that we grew at nearly 10% for about 4 years, and in that time, almost everything started looking up. But immediately after the Euro crisis, and that Eurozone crisis had a deep impact on India, but much later. So we started slowing down after 2012, and that slowdown impacted a lot of the regulatory mindset, particularly on human rights and the environment issue. So when a new government came in 2014, the very simplistic argument was that what's holding up economic growth is these very tight regulatory mechanisms that we are importing from largely from the European Union and are therefore holding up growth. And therefore, you saw a tremendous amount of dilution in environmental standards and human rights standards from 2014. Environment certainly, and over the recent past, particularly what Dithhi mentioned, when we looked at the kind of reform measures that we took in the labor law, which came, smack in the middle of a very strong first wave of COVID, it resulted in the dilution of anything that we had even on paper. And Dithhi was very forthright in saying that even earlier, the regulation was very insipid. And to then dilute it further was landed the entire labor sector into a big mess. And therefore, you have a situation where our major labor laws, which were at least on paper pretty tight, have been diluted significantly. Similarly, we have an exactly same issue. In fact, a much more precipitous issue where the environment is concerned. And there you see that almost everything has been changed, flouted, and the pace at which very pernicious projects have been cleared is been alarming. So the context is really the slowdown that we have seen over the last decade. And instead of understanding that economic slowdown is a consequence of several other issues, which includes infrastructure, the rule of law, and so on, what we have done is this very simplistic argument and this very populist argument that what stops business growth, what stops wealth creation, which is the new buzzword in India, is tight standards. And therefore, the only thing to do is to make the standards relaxed. And that's why, Induja, that's why this particular summit is so important, because what we realize is that the science of regulatory standards and the rationale behind having very transparent human rights records, behind having very clear rules and regulations on supply chains, on traceability, etc., is very important for a country like India. And it will only come here if there is a strong pressure from the European Parliament, for example, from the European consumer. So we saw that. We've seen the change over the last 25 years when we did move pretty significantly on issues like child labor and so on. And that was directly a consequence of the pressure that we got from the German consumer and from the French consumer and from the European Parliament. So in today's context also, if we are to awaken a regulatory structure that is weakening on every front, particularly on human rights and on climate change, we will need to ensure that we have a very clear answerability and an accountability to counterparts in the European Union. Over to you.
Yeah, you give a good overview of what's happening in Indian context. So I wanted to ask you whether there is a there's a case for responsible business in India as of now. What do you think is there in the current COVID situation, or because we see that as you and Dithhi said that there is a relaxation of like all labor laws at state level as well as central level, and also the parliament is not functioning. Everything is being done by the executive. So it's very easy to do that for making business happen. So at this situation or for near future, do you think there's a case for responsible business in India?
That's that several billion-dollar question. Yeah. Okay, so we've all become pessimistic these days, and for obvious reasons. So we are, we all tend to be, I guess, a little more cynical than we ought to be. But that's my confession. Death all around. Death, actually, people gasping for oxygen and dying every day. People very well. So the mood is terrible, to put it in as an understatement. And what's happening in this is a fact that businesses in India have suffered like they have never suffered. A few firms are doing well on the stock market, which is what happens typically during any disaster anywhere in the world. So you will have a few of them doing very well during wars, earthquakes, cyclones, etc. And the same is happening with India. There are a few, just a handful. You can actually count them. Those who are doing well, their share value, jumping from 800 to 2200. And I'm actually quoting one particular business house, which is the biggest we have. Which clearly has benefited tremendously as people have died. But beyond that, business in India is in shambles. And that is because consumption has been steadily going down for the last 4 years and then going down in a hurry in the last 15 months. So businesses right now are in a situation where they simply don't care. And as a result, you will find that every possible trespass of any law is happening everywhere. Also, what has happened is that one of the unfortunate impact of a policy measure called demonetization, rather silly one that we did about 4 years ago, and of a very large scale GST regime that was unleashed, and the recent COVID. What's happened is that most of our large business has tended to go informal. So when large businesses become smaller or formal businesses become informal, then the compliance to the law becomes far more relaxed, because in any case most of them are exempt from legal and regulatory standards. And as a result, you have some of the most glaring examples of abysmally poor pay. All of you are all very clearly very aware of what is happening in India, but you saw last year what happened with about 40 million people who were uprooted and about 10 million of them who walked back home. And home in India is a few hundred miles away. It's not in the neighborhood. And these people walk back. Now, why would they walk back? Why would people leave their jobs and go even if there is a temporary lull in employment? That is because the wages they get paid are absolutely and inhumanly low. So most of our workers, I don't know whether you know this, but 87% of India's population, 87% of India's population earns less than $150 a month. Right? So that's almost the entire workforce. So if we are paying $100 a month to somebody, there is really no buffer for that family to stay when there is no work. It is just left completely to the wolves, and that is why one starts walking down. Now, most of these people are paid well below the minimum wages that are stipulated. So, in this case, to get back to directly answering your question, in this case, if one is expecting the corporate sector to be responsible and to be more than responsible, as the as the business guidelines say, then one is flying kites, and that is not going to happen very quickly. On one hand, there is very little incentive for the business to do so. On the other hand, there is a government that simply doesn't exist right now. It has just disappeared from the scene, and therefore there is very little regulation. It doesn't even exist in the healthcare sector. So to expect it to work in the labor sector is really to expect the moon. And that, unfortunately, is the problem. However, and my last sentence is, however, what will happen is that as we recover, India's recovery will depend entirely on the foreign market, because there is no domestic market. Right now, there is no private consumption happening in India because incomes have been falling drastically. 150 million people losing their jobs, 7.5 million people losing their jobs just last month. So when there is such a huge job loss, personal consumption, private consumption in India is going to fall. Public consumption has fallen because the state doesn't have any money. And therefore, recovery will depend on what you guys in the European Union will buy from us. And when the corporate sector in India will sell or will try to export, then the questions that the German parliament or the French parliament or the British parliament will ask will be tough questions, will be questions on transparency and accountability. And that is when those firms that meet those standards will benefit. So that's the silver lining. That's the hope.
Thank you, Amir, putting that perspective, the truth out there. We have a question from Dr. Ritumpra. Do you want to ask Dr. Ritumpra? Or should I just read it?
Yeah, it's there on the chat.
Sure, I can just say it. So my question is to all the panelists over here, because we are having this EU-India People Summit, and the purpose of the summit is to create certain strong interventions from at least the Indian diaspora within the EU-India relations, which we are going to see developing given the fact that EU and China are on loggerheads at this moment. So there'll be a pivot towards India. So my question is that what should be the intervention look like, especially in terms of labor security and income security within India going forward? And also keeping in mind that recently, like Uttar Pradesh government in India has done away with 30 labor laws just to attract investments. So what is the suggestions from the academia and the experts from India specifically? Thank you.
Dithhi, I think you should take this first.
Thanks. Well, I actually would like to respond to it in a larger question again, which is, I think one framework that we need to think about possibly if we want to look at some kind of equality of power, because there's also the question of balance of power that we are talking about. So when Dr. Amir was talking about that the EU should put pressure on India to implement due diligence laws or human rights standards, I think I have a serious difference of opinion on that, because I don't think it's a good idea for our one-time colonial masters to be today once again becoming our new colonial masters, telling us what to do. So I don't think that's a very exciting proposition, because there's somewhere we have to address the question of balance of power and between the global North and the South. And in that, I think one of the things that when we are talking about what is the intervention that we are looking at, I think what we need to put in in our imagination, I guess. At this point, it's all about imagination. It's not about what we can put on paper, because I don't know how the people who make papers are really not interested in this. But I think it has to be put in the imagination that somewhere we have to respect the sovereignty and the legal system and the justice system of the countries in the global South. Now, the whole idea that we're talking about is that we assume that countries in the global south are corrupt. We assume that the countries of the global south are inefficient, they are corrupt, they are not able to do their job properly. But the whole idea of that is also that who actually brings this corruption in? Who is it that corrupts our governments? It is the big capital which comes in and corrupts our governments. It's not like our governments are inherently corrupt. And it's not that it's only the global south that the governments are corrupt. The governments in the global north are equally corrupt. So it's not like we're talking about corruption as an indicator of whether a government can function or not function. The question is whether we can have laws which we push for in our own countries, which address these questions of standards, which we are fighting for over here, which is the labor laws that we are fighting for. We are looking for income security. These are laws that have to be done in the global south itself. And we should have the power to take punitive action against the multinational corporations who are violating these laws in our countries. And it is to be the responsibility of the countries of the global north, to where these companies belong to or is home to these countries, to support those actions. The question is, when Bhopal gas tragedy happened, which killed many more people than Rana Plaza, like there were 20 Rana Plazas or 200 Rana Plazas in Bhopal gas tragedy. But why could we not bring Union Carbide to justice? We couldn't bring Union Carbide to justice is because the United States government refused to let us do so. They refused to let us extradite the Union Carbide chairperson. So the question is, if the United States government would have allowed us to charge the Union Carbide chairperson, we would have been able to make some Union Carbide pay. The same holds true for Kick. The same holds true for other brands. Same holds true for Total. The question is, as long as the government is willing to accept the Southern government's verdict and respect it and support it, we are not going to be able to make a different position. We're not going to move forward. We're always going to turn towards the other country and say, help us. The question is, how can we, with the legacy that we have, actually today forget about our legacy of fighting against our colonial masters and today turn towards them and say, your justice system is superior to ours, your justice system is better than ours, and you must give us justice. How is it that we are going to be able to do that? And why should we do that? And what should be the system? Why should we submit ourselves to a system that actually pushes us towards that? And I think that is something that we need to recognize and move forward towards.
Thanks a lot, Dithhi, for that intervention of yours. If I can further add to it, actually, I do not come from a place where I have this binary between the colonial legacies and non-colonial infrastructure of the South, global South. My position within the European Union, I'm an Indian citizen. I'm a diasporic Indian citizen. I'm going to influence the European-Indian relationship in the best possible way that I can. My question comes from the point where I very well recognize the fact that India was the framer of the Universal Declaration of Human Rights, right? Hansa Mehta was the woman who said that human rights belong to all humans, not men. So I come from that point of perception that India has a big role in framing these human rights, and therefore India should have a responsibility in carrying forward the methodologies that can effectuate these rights on the ground. And these methodologies should be respected not just by the Indian governments, but also by the European governments. So I do agree to your point to an extent, but I would not put into a colonial and non-colonial binaries, because I feel that that would not lead us to any further, development of it, because we have seen the government taking that apologetic stance and saying that, hey, you colonial leaders, you can't tell us what to do, but at the same time not doing enough in their own countries as well. So having said that, I wonder what Amir has to add to it. Perhaps he can say what, with the current government, if there are certain ways that we can go forward, or do we have to, as diaspora and civil society, interject and say that, no, we have to keep our foot down? Amir.
Thanks, thanks, Dithhi. I get your point, but I still go back to what I was mentioning. You know, what's happened is that and here is just a large political statement that I'm making. What's happened is that over the last few years, internal pressure for justice, for fairness, has just evaporated, and that's the tragedy that's happened in India. What Dr. Ritumra spoke about just now, about how India was the font of a lot of work on human rights, and where we were moving forward in terms of transparency and accountability, purely in a sui generis fashion, with the Right to Information Act and so on, has all been steadily diluted. And all the institutions that we had, which would question the high and mighty and the powerful, have all become virtual stooges and puppets of a very strong government. And therefore, it is in that context that that some of us in civil society believe that the only pressure that seems to be working is external pressure. It is when the United States asks the Indian government for accountability on distribution of aid and charity that is being sent for COVID victims. That's when the Indian government actually wakes up and tries to give an answer. When I file a right to information appeal and ask for details, I am left hanging. And the RTI, you know what's happened to the RTI Act itself. So that's my point, that beyond the very obvious thing of the UK being a colonial master, and can't blame the rest of the European Union for that. But any pressure that has come from outside, especially from the US and European Union, has been pressure that has actually worked. And it is only then that you will find a very hostile and a very dogged government respond. That's the reason I'm saying that the responsibility of making the Indian government answerable disproportionately falls on people like some of you who are the diaspora, and the others who represent Europe and Europe's ambition of working with India in trade issues. So that's the big problem we have, and that is why I make this point again, that the Indian government, immune from Indian institutions and extremely disrespectful for Indian civil society, and now unwilling to answer any question. I mean, our Prime Minister hasn't addressed a single press conference in 7 years. He has not taken a single question. So what do we do? So the next time he is in Paris, you ask him that question, because there he can't dodge it. In Delhi, he just walks away.
Yes,
and this is this is what all of you know very well. So that's the reason. That's the reason one is saying that there has to be external pressure. Yes.
Yes, I think both points are valid. I think to bring back to the business and human rights perspective, what we see is also like, where does the responsibility gap for ensuring compliance of human rights obligation stay, because host states like India also have obligations, and what Amir is saying is that the state is not doing enough at all. I sort of agree with it also, and I agree with Dithhi also. Like, we can't expect everything to be done by a foreign countries, especially in this human rights issues within the supply chain. So both valid points, and I think if other panelists don't have, then we can move on to the next question, which was put in the chat. Yeah, what about the role of big tech? Like, it's also very new, like the digital technologies are moving very fast. Do you see these mandatory due diligence applying on the big data companies also? Does Johannes have to add, or anyone else? Please go ahead. Or Marie-Sophie.
Well, maybe let me just say one thing to this, and then also to the other point. I definitely think that big tech should be included. I believe the way the European endeavor is framed, it would also be covered if they have their head offices in Europe. What I did want to say about the EU-India relations is that during the upcoming summit, from what I understand, there will be an explicit agreement that the trade negotiations will go forward for a EU-India free trade agreement. Well, of course, we can say that we can look at any of these free trade agreements very critically. I definitely think this here would be a necessary intervention for pressure by civil society to make sure that there's really strong human rights clauses in it, and since those kind of agreements probably won't be able to be stopped, we just need to make sure that they anchor the International Labor Organization standards and the like. And then I wanted to also say to maybe have more responsibility on the Indian side, because I mean they are not really involved in the EU due diligence process, is to point at the process happening at the moment on the level of the United Nations, of the treaty for human rights and transnational corporations, which is already, or in October, it will be the 6th or 7th negotiation round. And India is partaking in it, and it is more or less going to be a binding version of the UN guiding principles, and it would be, of course, a really important perspective if India as a country were to put forward strong proposals. And I think the EU has still not taken a stance on whether it's going to participate very actively. The German government is currently getting more and more annoyed with this apathy, let's call it, from the EU. So with the EU due diligence regulation coming up, I hope that the stance will change, and having an internationally binding document on business and human rights might also just change the dynamics a little bit, so that we don't have this like EU as a do-gooder, but more on a level playing field kind of approach.
Yeah, thank you, Mary. Dithhi, go ahead.
Yeah, well, again, just to respond to what Marie-Sophie just said, and this is the old debate of the social clause, and I hate to bring that up again. And the question is that when the whole WTO actually collapsed on the whole question of the social clause, that should there be a social clause in trade agreements? And if we are bringing in the due diligence law within the trade agreements of EU-India FTA, we are again going to skew the balance of power between the EU and India. And already we know and that's not, we don't really need to spell it out over here that how much stronger the EU is already in the context of India. But if you really put this as a clause, what you will really end up doing is skewing the entire process of the trade agreement towards the EU, and very little would be left for India to negotiate. And saying so, I would also like to say something else in this context, is that we are constantly fighting this battle between whether India as a country should be defended or not defended, given what India at this point is, because we all know what we are going through. We all know what kind of a government we are enduring at this point. So when we are really talking about that there should not be a EU-India FTA with a social clause, we are possibly going to end up defending a government which is actually breaking down all our rights and all our the entire social protection structure that we have. So, but we need to think about this in a long-term perspective, that this government is not forever, or at least we hope so. So at least we're looking at it that this government, the free trade agreement will live beyond this government. And therefore we need to have, when we're writing this down, it should be a writing down of a more equal agreement than a very skewed agreement. So I think somewhere we need to keep that in mind when we're talking about due diligence laws and human rights being drafted as part of the trade agreement to ensure that there is some kind of human rights protected in our country. One thing that I would, in this context, the other thing that I would like to bring to the due diligence law in itself is that what is the penalty that we are looking at? The penalties that we are looking at is a civil liability, our fines, and the last and the most severe punishment is import ban. So what does an import ban mean for a country which is importing from, say, India or Bangladesh or Sri Lanka? It means a one-time loss for that package, for that consignment of their imports. But for what does that really mean for the country that is exporting actually? It means that you're really spoiling the name of the country because nobody else. So you become a boycotted country. You become a country where nobody would like to come because you've been caught in violating the law. So nobody would like to come here. So what the possibility of a developing country to actually move up the scale is being further compromised. You're really saying that we will do everything possible to keep you where you are. And we'll use even the good laws to keep you where you are. We will do everything possible to keep you where you are. So this is a very tricky situation. And when we are walking this path, we have to tread very carefully.
Yeah, thank you, Dithhi. In a way, I understand your point. What you're trying to say is like we have to have that balance of power to be maintained within the trade agreement. But then at the same time, of course, we have to respect and try to enforce human rights from both sides, like from both sides of the agreement makers. Well, on this topic, we actually have a panel tomorrow, which will discuss on the human rights enforcement within a trade deal. So I hope that you guys can go and see that. But we have only 15 minutes left. So I would like to ask, actually we have one question before that in the chat on the role of big data. Does anyone want to take on that? Will big data come under the mandatory due diligence laws? Yes, go ahead, Johannes.
I mean, I think Marie-Sophie already commented on that in some way, and I mean, it's what and it's absolutely true that this legislation would apply to a large group of companies. I mean, all kinds of types of companies, including, by the way, also financial actors, investors, which I think is pretty important because they play a big role in. They can use leverage in a positive way, but they can also squeeze companies for shareholder value, right? So it's really important to include financial actors, and big tech firms would also be included, definitely, in EU legislation. And it's not just about production, supply chains. It's really about value chains, which means it's also about services, human rights impacts of services, human rights impacts of things you sell, actually, not just the stuff you source as a company. So it really would cover that. And I mean, at the Resource Center, we are having a debate on, for instance, the human rights implications of artificial intelligence as well, which, is in many ways seen as a solution by policymakers, including in the EU, but which comes with big risks. And we would hope due diligence could be one of the legal means to also capture human rights impacts of artificial intelligence that is developed by EU companies. And if I may briefly just comment on the other important points that have been made, and maybe that's also already my final statement, I don't know, looking at the time. I think we're all aware that this EU mandatory due diligence is not a silver bullet that will solve all the issues that are there, right? All the injustices that also have historically grown. There is definitely this whole aspect of local institutions, laws, etc. And there's also the aspect of trade and investment policies and how to align those. I'm not an expert in those, so I won't comment. But what I know is that sustainability chapters and agreements and trade and investment agreements so far have been pretty meaningless. That's what my impression is. And when it comes to this due diligence, and when it comes to the responsibility gap that you addressed, that you mentioned in Induja, I would say this EU mandatory due diligence is one very important instrument to address that responsibility gap. And one specific aspect of that responsibility gap, which is the fact that big corporations headquartered here in Europe make massive use of globalized production, make massive profits, but are not ready to assume global responsibility along with their global production, right? And it's that what we want to address, making those companies accountable for the human rights impacts they cause, contribute to, and are linked to. And it's really about human rights, universal human rights. It's not about replicating legislation from EU countries in another country. It's really about rallying around the universal idea of human rights. And I think that's also something that civil society across countries and regions can easily rally around, right? It's really about strengthening human rights with all the legislative measures we have. And this mandatory EU due diligence can be one watershed game-changing measure, I would say, to hold these companies accountable, EU companies, and also address the big power asymmetries that are definitely there. So it's a reaction to some extent, I would say, to those big power asymmetries, and then trying to rectify those. Although, as I said, it's not going to be the only solution. Yes, but I basically agree with everything that has been said. Just to say that we are very aware of the limitations, but also optimistic when it comes to the transformative, game-changing power, hopefully, of that EU due diligence, when it's a meaningful legislation that is not just superficial and a tick box exercise. But we're optimistic that hopefully we'll have a good result, and we should all work together on this. Thanks.
Thanks, Johannes. I think Ritum Prof. Yes, please.
Thanks a lot, Induja, and thanks a lot, Johannes. The reason why I wanted us to reflect a little bit on the big tech was also this, that India is not in the same position as it was with the Industrial Revolution. When it comes to service industry and when it comes to big tech industry, India is perhaps much more capable of producing AI and technology in the cyberspace, which can be disruptive and also productive for the rest of the global world. So here we have a very level playing field, yeah, where EU is perhaps more persistent, especially with the European Council. As we can see, Heiko Maas is really, really persistent on getting platform regulations, etc. And there, on the other side, we have this Indian landmass where the government is not very, willing to regulate platforms which might actually go on to harm their own political position or power monopolies, so as to say. So I just wanted us to also think a little bit on that terms, that here in the cyberspace domain, in some ways, both these entities are very equal. Rather, India has an upper hand than the European Union, because European Union doesn't, even with the UK legislation and the European Union's own legislation, the only effective platform we can regulate is Vimo, not Facebook, not Twitter, not Google, not YouTube or any of them, because they're all based in US. So we are effectively in the same position, both these regions. So yeah, I wonder what Amir or Dithhi or Marie might have to add to that. So yeah, go ahead, feel free.
Little to add. I think that's the situation, and given the trade patterns that are emerging, where India's trade is more and more skewed towards China and North America, the European leverage of its imports is getting lesser and lesser. But in tech areas, in energy areas, Europe remains a very strong partner, and that is where one would expect it to use the influence it can to ensure that Indian regulators and Indian institutions respect the obligations.
Anybody else? Does Mary have anything to add?
Well, maybe just on I think the big tech is a really big thing of its own that will need to be addressed sooner or later. I think things are developing so fast in that area that the legislators just are too sluggish to react. And I think we need to be careful to project too much into what this due diligence law can achieve, not only in this area, in all different areas. Like I'm also currently looking quite extensively into what effect due diligence can have in the in the area of gender, and I think we're kind of seeing, oh, this will have a real impact on all human rights and we can use it for anything we want. But I think we should just I think almost as Johannes said, we should use it in the way that we can and see the I would say especially the value of it in using it in participatory or collaborative spaces. So for instance, having workers really act in their own names, or that unions are given the rights or are respected in a better way, that they can stand up for workers. We should see that, or hopefully that there will be some collective liability, or how do you call that, when you can sue as a union or as a collective. So I think that there is a lot of really great chances, but it's I think that's really important to stress. This is in my opinion, or hopefully the first step, and hopefully the turning point to a better approach to trade. And yeah, we see this as a great first step and a really necessary development, and hope that a lot of steps will come after this.
Yes, I share that hope also. I think everybody here also share that hope. I think we have only 5 minutes. does anybody else have anything to add, or we can end the panel? Yeah, I mean, like, if we could end with a point where, like, if you can suggest, like, what is the minimum standard that you would want when this legislation will happen? What would be the minimum standard that you would like to see in this legislation, forthcoming legislation? Is this also $1 million question? I think so. Can you say that in a sentence or two sentences? It's really hard, but you are really passionate on this subject. So I think I could ask this, like, what do you really want to see that should be there? Is it access to justice, and, like, or what is it? That would be my take. So that's why I just put that there. Everybody can join here. Like, we can start with Dithhi, and then we can go.
Well, I guess it's very difficult. And I think, well, I would say that we would like to see some form of equality between nations in bringing this forward. And how do you implement the law? There would be some notion of equality of nations and peoples, and somewhere we'll be able to do that if there is respect for freedom of association of people, so that they can actually take complaints forward, they can fight for their rights. And unless you have a collective identity, it's very difficult to do that. So I guess that's something that we need to, that we would like to see.
Yeah. And Dr. Amir, do you have something to add? Okay, I don't hear from him. Johannes.
Sure. I mean, I think EU NGOs and others have identified a few essential elements of that legislation, which are like due diligence obligation covering the full value chain, the crucial role of meaningful rights holder and stakeholder engagement, so giving power to workers, communities, etc., to really co-shape a company's due diligence process. And there is this aspect of civil liability and access to remedy, which is crucial, both in terms of strengthening the rights of affected people, but also in terms of the preventative effect, as was said before. And I think the overall outcome of this, and that's the measure of success, is tangible improvements for people along global value chains and in production countries, and I mean everywhere where EU companies either produce or are linked to and involved through their value chains. And that's it. I think tangible outcomes and improvements for those that are currently suffering and marginalized. That's my final point.
And, yeah, Annie, do you have something to add?
Hi. No, nothing to add. I echo all the comments from my colleagues. I think it's a critical time for EU and India relations, and I think this could be, really the moment that we see, whether or not these laws will actually make an impact on the ground. And I want to just emphasize again that it's very important for the government to have a buy-in. They can't work separately. So the EU just putting out this law and then India is supposed to follow just on its own, that won't happen. There has to be a higher level buy-in for sure. So I hope that happens, and I guess we'll wait and see. But I think the equal footing point is the most important, and I hope, if nothing else, that's kind of what happens as a result of this. Thanks.
Yes. Since you are back, Amir, do you have a take on the minimum standards that should be there?
I mean, I have nothing to add. I think between Dithhi and Johanna and Annie, they've said it all. There is this, I mean, the whole trade pattern is based on reciprocity, and given the fact that India, European, EU relations are important for us as we are trying to get back to a trajectory of increasing exports. We had a bad time. Our exports have been tanking for nearly 39 months now. So if we are going to get back on that, then we will need to have, we will need to be able to negotiate well, and to do that, it will be a situation where we will have to hopefully meet those basic minimum standards that that any trading partner will insist on. So,
yeah,
thank you.
Yeah, thanks. So we are 1 minute over the time. Mary, can you quickly say it, and then we can end the panel discussion?
Yes, I think I will just say that I agree with the other speakers. For me, just also given the German situation, a strong liability regime with a reverse burden of proof and would be really crucial.
Yeah. All right, thanks. I think it has been a wonderful and fruitful discussion, and I surely have learned a lot from this, and I'm pretty sure like anybody who is viewing also have. So thank you for joining once again, and have a wonderful rest of the day. I'm ending.
Thank you so much. Thank you, everybody. Wonderful seeing all of you. It's just been
you.
delightful. Thank you very much. Thank you.
Thank you. Thank you very much. All the best.
Yeah, all the best.
Thank you.
Thanks, Induja.
Yeah. Thank you.